Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you decide how to protect yourself, your family, and your business when it comes to law matters. A better understanding of the law puts you in a better position to decide how to handle things. At times, we try to prepare you so that you can handle some issues yourself. If you decide to seek outside counsel, professional counsel, our goal is to have you be better prepared, save time and money, and hopefully achieve the best possible results. As always, we want to welcome and thank Attorney David Bizarre from the Bizarre and Associates law firm in East Providence, who continues to weigh in on the subjects that we tackle. So today we're going to be talking about the anatomy of a trial. In our last session, we discussed issues like initial filings and up to trial. Various trials could be business, could be personal injury. What actually happens when you decide that you have to go to trial? As we said, it's true, many cases don't reach trial, whether it's civil or criminal. But here we are looking at civil cases. So what happens? What's the anatomy of a trial, David?
Okay.
Let's go.
So we'll take our time today to go through what happens when you've done everything you can to resolve a case short of trial. You went to mediation, didn't work. You went to arbitration, didn't work. You did all kinds of negotiations back and forth, it didn't work. So we can talk primarily today about civil trials. There is a difference in the process for a criminal trial and a civil trial based on a couple of factors. In a criminal case, it's the state that's bringing the charge, so the state would be the plaintiff, so to speak, the prosecutors of the case. And when the state brings a case on a criminal basis, obviously the burden of proof is different. You have a burden of proof beyond reasonable doubt. That doesn't mean no doubt, but beyond reasonable doubt. It's a high standard that the state has to prove its case. In a civil trial, the burden of proof is much different. It's a preponderance of the evidence. It's take a scale and put both pieces of evidence or the weight of the evidence on both sides of the scale. And in order to prevail as the plaintiff, you have to just tip the scale slightly. So it's just beyond 50-50, so to speak.
And if there's a trial, who gets to decide whether it's bench, jury? How does that play out?
Okay, so it always depends on the type of case. So certain cases by law or statute or constitution, you have a right to a jury trial. So as we're saying, in criminal cases where you're being charged with a felony or a crime that's going to be tried in superior court, you have a right to a jury. You have a right to a trial of your peers. That is by law and constitution and statute that says that a defendant has the right to choose whether or not his trial is before a jury of his peers or waive that jury and have it tried by the bench, the judge.
Do you ever weigh in on, let's see if we can go one way or another, if you are representing someone who A, is innocent or B, is guilty, or how does that affect your judgment, David?
Well, certainly it's going to, in a criminal case, depend on who the judge is. So if you're in front of a judge that has a particular bent on certain types of cases, and you've already requested a jury trial, you're going to stick with that. If you think you have a good shot, and depending on the facts of the case and knowing the bent of a particular judge, and also more importantly, the complexity of the trial and what needs to be heard and what a judge might be better at figuring out the facts of than a jury, you might waive the defendant's right to a jury trial. In a civil case, it's much different because if it's the type of case that you're entitled to a jury on, the plaintiff has the right to have that jury, but so does the defendant. So you as a plaintiff may waive your right to a jury, but the defendant may have requested the jury trial in the first instance and may not waive it.
Okay, so you're going to have a trial and say there's going to be a jury. You have to select a jury. Right. I think everyone hears the term voir dire, right? Well, let's go through that.
So we will get there.
Okay.
But here's what happens.
I'm jumping ahead.
Before we get there. So when you come in, you've done everything you can, and now you know you have a trial. And so you've done everything to go through your case and know what your evidence is and what you need to present and what the other side is likely to want to present. There's oftentimes pretrial motions. many times those are motions in limine, for example, where the defense may say, we know, based on a discovery, that they want to present this particular witness or this particular evidence, and they might say to the judge before it gets in front of the jury in a preliminary motion or a motion in limine, look at this evidence. We don't think it's admissible, and we want to know from the start, before the trial even begins, whether or not you would consider allowing this evidence in or not. And so there could be arguments over evidence, whether it's a particular witness who may have some probative value but might be more prejudicial, or whether it's over some type of evidence. For example, you might see this in a criminal case quite often, where they try to exclude a weapon that was found or evidence that was found based on a search warrant. And they might say that that search warrant was defective, so that evidence shouldn't be allowed to come in. Those are the types of things that are the subject matter of preliminary or pretrial motions.
So when that's going on, say, what is it, the fruit of the forbidden?
Yeah, the fruit of the poisonous tree.
Yes. So suppose you suspect that a piece of evidence maybe shouldn't be admitted because it came from some tainted source or whatever it is.
Right.
Who is likely to raise, are you likely to raise that if you're defending someone first, before the prosecution gets to say, right, and here is that knife? Who goes first? And
so we're mixing apples and oranges a little bit because we're back to a criminal trial, but that's fine because we're talking about preliminary motions. Mm-hmm. So most of the time, it's the defense that would raise an issue over the admissibility of evidence, and certainly over the admissibility of evidence that was obtained by a warrant, so to speak. They might challenge whether or not the affidavit that supported the warrant was sufficient, or whether or not the execution of the warrant was done in such a way that it was true to what was allowed to be looked at. And so oftentimes when you talk about the fruit of a poisonous tree, if something was discovered at, let's say, in a search warrant that led to the discovery of other evidence, you might say that other evidence shouldn't be admitted because it was as a result of what already was poisoned by the particular warrant or whatever the problem was with the initial search.
Okay. There's a pretrial motion, and when you're going through these things, do you have to submit written documents? Does the other side have to present written documents? Do you each get to look at each other's review and then take it before a judge to say, I think I want to eliminate this? How does that process work, David?
Yeah, so oftentimes the motion will be filed prior to the trial starting because the judge is going to want to know what your issues are. And so judges oftentimes, when the trial starts, will get the parties together before we are ready to pull the jury in to ask about what issues there may be in the case. So, for example, I had a products liability trial, and one of the things we did was we had an expert witness. This was a bottle that disintegrated when my client took the apple drink off of the shelf at, this how far back it goes, an Olmac store.
A few years ago.
Yeah, the bottle disintegrated and cut an artery and a nerve in her leg.
Oh dear.
And so what happened was the store collected the bottle and the remnants of the bottle, swept it up and put it in a box and put it in the manager's office. And then my client went in, my expert, went in to gather up the bottle so that he could examine it. And the defense objected because they said, how do we know that this bottle that was put back together is the same one that caused the injury? So it was what we call a chain of custody issue. And so the judge said to me, how are you going to prove it's the same bottle? Because I had the bottle in court and I wanted the jury to see it after my expert had put it back together. And so their motion in limine was to not allow the bottle into evidence, and therefore it would have not allowed my expert into evidence. So I said to the judge, well, how far back are they expecting me to go? Because the last person who had the bottle before I got it back was the defense attorney, because he wanted to see it. And so I'll call him first, and I'll work my way back to the expert. And they argued and agreed that no, their motion is based on when my expert got the bottle. So what I had to do was I had to have a hearing preliminary hearing before the trial started, to have the expert come and testify before he came, I actually called the risk manager for Almax, the person who was in charge of when there's accidents there, and had her testify. And her testimony was, my question was, when did you first become aware of this incident? And she said, when it happened. The manager of the store called me up. He said, we've had a very major issue here. He said, it looks like a war scene. I've never seen so much blood in the aisle, and this is what happened. And she said she instructed him to gather up all of the glass, put it in a box, and lock it in his office. And when was the next person to go in to see the glass? A week later, your expert came in, I let him in, I gave him the glass. And that was the same glass that was swept up from the incident? Yes, it was. So I established my chain of custody. In that particular case, what was interesting was what the defense wanted to rest their case on was that we didn't have the neck of the bottle, the pot that my client grabbed. And the reason was because when this happened and she saw the blood, she, without thinking, put it down on the shelf. They only swept up what was in the aisle. But my expert was able to testify that it was a manufacturing defect because the mold was too hot when the bottle was made, so it ran thin in the neck. And even though he didn't have the neck itself, he could tell by the thinness of the bottle going up what had happened. So I was able to prevail with his testimony.
So we're here today to talk about the trial. You're giving yet another indication of how much time is absorbed in pre-trial, and as we were talking about discovery last time.
At this point, we're done with discovery. All the discovery is done. We're ready to roll. They know I have this expert. They know what my expert's going to say because they deposed him. And they know what they want to try to stop from getting into evidence. So this is all preliminary to the trial, but it's like the day of the trial. So this motion is heard, and the judge decides. I've had other things where the judge may decide, no, that's not going in, or no, you can't argue that, but we now know what the ground rules are. So we're done with that, and now the trial is ready to begin. And so as you said, where does the trial begin? It begins with impaneling the jury.
Which is?
Voir dire.
Voir dire.
So the judge will call up a whole group of prospective jurors. In the civil trial, it's 6, but they'll usually put 8 in the box, so they're 2 alternates. They put them in the box, and you start asking questions. That's what voir dire is. It's designed to obtain as fair and impartial a jury as you can. Of course, as the plaintiff, I want a jury that's more favorable to my case, and the defense wants a jury that's more favorable to their case, but it's designed to make sure that there's no biases that would affect the case one way or another for the particular juror.
And of course, there are countless TV shows about these kinds of things. So you each have your set of questions. I want to get into those a little bit, but is it true or fair to say that having challenges for cause...
preemptive challenges, yeah.
It's easily won or not easily won?
So,
is it difficult to get through that? How does that work?
You can challenge for cause, or you can have a preemptive challenge, which is this juror doesn't feel right to me. You only have a certain number of those challenges that are not for cause, the preemptive challenges. And depending on how big the jury is, which in a civil case is 6 with 2 alternates usually in Rhode Island, you get maybe 2 or 3 preemptive challenges, and then the rest would be for cause. And so how do you get to those? It's based on the type of trial, the information you get from the jury, and their feedback to your questions.
So I have one other question about those preemptory challenges,
Yep.
the ones that let you say, I just don't want this one, this one, and your other side does that too. It's supposed to be fair and fair also based on, what's the listing? Race and gender and all. But suppose in your case, in your representing someone, maybe you think that gender or race might work well for you and someone is saying preemptory, he's out. Do you have any recourse with that, or you just have to bite the bullet and say next?
No one's ever going to tell you what it is their gut as to why they're exercising a preemptory challenge.
Okay.
There are cases that you're talking about, and usually they're criminal cases, where the state may be knocking out people, and you can tell that there's a reason why they're doing that, and that could be a prejudicial form of jury empanelment that might be challenged. You don't get that as often in civil cases, but I'll give you an idea of what goes into the voir dire and some of the questions you may or may not ask. So I had another case where my client was not a U.S. citizen. He was an immigrant. And I thought that that was going to play a big role in my case because of how he was treated by the defendant. And the theory of my case was he was treated by the defendant based on who he was rather than what he did. And so I told the judge in advance that there are certain questions I wanted to ask. And so first of all, what you do in voir dire is you start by telling the jury the story of your case. And you say, this is what happened, these are the people involved, these are the witnesses that will testify. And what you're trying to do with all of that is to first of all find out if there's any immediate knowledge that they might have of the case, of the people who are involved, or have some connection to it. So the defendant might be, let's say, a hospital. Do you have anything to do with that hospital? Do you work there? You need to know those kinds of things.
Are those general questions? Anybody associated with hospitals?
Well, here's the defendants. Does anybody know this defendant? Anyone work at that or have a relative who works there? That type of thing. So those are general questions you would ask. Do you know the plaintiff? If the plaintiff had a doctor, if it was a personal injury case, do you know the doctor? Do you have anybody who treated with the doctor? You need to know their intimacy with the witnesses and their familiarity with the case, and anything that might be a bias one way or another with that. So those are the types of questions there. In particular, in this case, you dig in a little bit more. And so I was concerned if I had people who didn't like immigrants for whatever reason. How do you figure that out? What do you think you might ask? Any idea?
No, I'm not going to bite there. I'm not going to bite it.
Okay.
You go.
So
do it.
This is what I did. I told the judge I want to know where they get their news from.
Okay.
And so we go through the whole thing, and I said to the jury, we're going to ask questions. It's not designed to make you uncomfortable or dig into your personal life too much, but we need to know a bit about you. And the judge said, and with that, he's going to ask you, what do you watch for TV? So I said, so what do you watch for TV? And the first guy says, Law and Order. So I look at him and I said, very good show, I watch it myself. However, remember, those lawyers have scripts. The other lawyer and I don't. We're just here being lawyers, we're not actors. So don't hold us up to the standard that you might see those lawyers on TV, because everything's scripted out for them. And then with that, I asked, where do you get your news? And so what I was looking for was, where do they get their news? Fox, MSNBC, CNN. One guy said, the internet. And I said, I don't even know what that means. Tell me what that means. And he looks at me like he's indignant that I would even ask that question. And I'm just trying to be nice. So part of what you're doing is to see what kind of connection you might have with each of these jurors, because you want to make a connection with them.
Sure.
So guess who the first one I got rid of as soon as I was done with being indignant with me and we had gone through all the questions? Juror number 6. Hand it to the sheriff. Normally you like to be a little quiet about it. You don't want the other jurors to know you're knocking some. I was very pleased to knock that fellow off the jury.
Well, what's wrong with Google, David?
What's wrong with what?
What's wrong with Google? That's
no,
the internet.
I don't. He was indignant with me, so
it was
it's
his
just
reaction
the
rather
reaction.
Than...
I didn't care really, if he got it on Google or I don't know what the other ones are on there. Drudge Report. I don't know. Whatever they are. Breitbart, whatever it is. He wasn't going to answer the question, and he was indignant. So we didn't have a connection. He had to go.
So let me follow up with, you were asking what I would ask. How about you happen to know that the person who you represent really isn't a likable person? You already know that. Maybe you might know it because you've talked to him, but maybe you just know it because of you haven't been able to coach him into smiling or whatever. Right. How do you deal with that when you're trying to select a jury? Do you like my...
No,
what can you
I try to
possibly
get him to like me.
Okay.
Because I'm the one doing most of the talking.
Okay.
Most of my jurors, most of my clients are very likable, so I'm not worried about that.
Okay.
But really, you try to coach your client on how to testify, look at the jury, look at the judge, answer the questions completely, but don't offer extra evidence that's not being asked. Be responsive. You work with your client quite a bit on that before a trial.
How do you go through, and I know you've mentioned this before, often when someone caused a problem, car accident, there's also a second and a third and a fourth, there are several parties involved. How do you get at, maybe your guy is the second one in line, culpable but not primo, not dominant. How do you go through and explore that and get to that, how they all think about it? Because if he's guilty, he's guilty.
Yeah.
How do you work with that?
So that's going to be a number of different things that get there, but that's further down in the trial. Because all we've done so far is voir dire.
But even selecting a juror, how do you get to know whether, if someone did something wrong, then there should be consequences? Yes, yes. Well, someone is a little more at fault than another. Someone's a little more deserving than another.
You can ask questions about comparative negligence and understand that you may not be 100% at fault, but you might be partially at fault. But what you're really starting to get into is what the judge's instructions might be. So you just have to say, if the judge instructs you on this, will you be able to follow the instructions of the judge? So that's really how you're going to handle it. And you need them to pledge to you that they're going to follow the instructions of the judge.
And you hope that that works.
Well, you get a sense of the person, and you ask the questions of the person so you can get a sense of whether they're going to be a rule follower or a rebel, whether they're going to be disagreeable with the other jurors in there or not. Knock them out. And so you get a good sense of what you need.
Who gets to decide, or how is it decided who the lead juror, the chair?
The judge picks the foreman.
And how does that happen?
It usually doesn't happen till the end of the trial, when the judge gives the instructions and said, now we're going to have you go deliberate, so you'll retire to the jury room, and juror number 3, you'll be the foreman.
How does he decide that? Flips a coin?
Picks whoever he wants.
Okay.
Or she.
And you have no input to that either way?
No, that's done by the judge.
Good to know. What else do we need to know about jury selection or getting in paneling them?
How much time do we have?
Oh, about 6 minutes.
Okay. So we've picked our jury. So the next step is opening statements. So the plaintiff has the burden of proof. The plaintiff goes first. And the plaintiff will lay out their case. This is what the evidence will show. They'll produce, a list of witnesses and what they expect to say. You'll tell the story that the jury is going to hear. So a good opening statement isn't really just a roadmap about what the case is about, but it's a story. And so you want to catch them right in the very beginning of the opening statement. And so that particular case I was talking about, where my client was from another country, I might have started with what the defendant said to him, which was something along the lines of, you, with a very expletive word, immigrants can steal from Walmart and Kmart, but you're not stealing from my cafeteria. And so you try to get them in right away and understand where you're going, and then you give them your story. The defendants will usually open, they don't have to, but they'll usually open at the same time because they don't want you to have the whole stage. They can hold their opening statement to when they present their case, but usually they'll open at the same time.
Do they ever change theirs based on what your theme is? Maybe they hadn't accurately predicted what you were going to do?
Yeah, I'm sure they do. They should. They should, but you can do that on the fly.
How do you determine, you're not supposed to be argumentative, you're presenting your opening, you save the arguments for later.
Right.
How much leeway do you have in that? Do people object to what you said, saying that's argumentative even at the outset at times?
Yeah, so it's not always good form to get up and interrupt someone in the opening or closing, but sometimes you have to. And so you might shake your head and slowly stand up and say, Judge,
good to know.
I'm really sorry. And it's not my practice to interrupt, but this is so far over the line, I have to object and ask you to instruct counsel to stick to an opening statement.
Okay, and he decides how that goes.
The judge may say, sit down, or he may say, yes, you're right.
That is egregious, so stop it. Okay, so Next, opening statements, both sides.
Now the plaintiff presents their case in chief. And so you present your evidence, which is in the form of witnesses. It may be in the form of documents. It may be in the form of stipulations that both sides have agreed to or facts that are agreed to. You present your case. So the first witness testifies, you do the direct examination, the other side does the cross-examination.
And what if along the way new evidence comes up? When do you have to present that to the other side? Do you really, as they do in TV shows, say, it just came up?
Yeah.
And keep them unaware? Is that kosher?
No.
Is that allowed?
Yeah, I mean, it happens. It's not too often that it happens. It's kind of rare because you've been preparing this case for so long. But I've had cases where they subpoenaed in a police report that no one could find during the whole thing, and all of a sudden they find it and they bring it in. So yeah, you got to look at it, see what it is, and talk to the judge and see, is that reasonable to produce it now? What's the reason it's so late? And maybe it's admissible, maybe it's not.
Okay, so one side presents, cross, other side presents, cross, and then?
Plaintiff rests. Defendant might make a motion for a directed verdict. They didn't prove their case. The case should be dismissed. The judge may either rule on that or he may hold it and say, nope, you present your case. And then the defense presents their case.
And then?
Then the defense rests. They might renew their motion for a directed verdict. The judge may grant it. He may not grant it. He may say, no, I'll hold on that still. And then you do your closing arguments. Defense first, plaintiff last.
What's the advantage of that?
You get the first word and the last word, but you also have the burden of proof.
And then the
judge gives his instructions and sends out the jury for deliberation.
So I have to ask this. I know I'm not supposed to. No one likes to talk about it. Why is there not an opportunity for what's called jury nullification? You know what that is. Maybe you'd be in a better position than I to, and you should talk about what that is. But apparently, that is not something that's allowed in the courtroom. The judge does not say, but you have to just and only make your decision based on evidence. We get that. But if something doesn't seem right, then what?
So, first of all, most of these cases, these civil cases, it's the judge is going to tell him, you have to decide the facts. My instructions are the law. You have to follow my instructions on the law. And then apply the facts that you find to the law. In most of those cases, it's not about whether or not a statute or a law or a rule is correct. And I find that you're not going to get jury nullification. They're just not going to find in your favor if they don't think that that statute should be applied.
Okay, so they deliberate, they come back with
a verdict.
And then?
The judge has the foreman announce the verdict. Did you reach is that true? And then you can poll the jury and ask if all of them agreed. And then the jury thanks them for the service and sends them along the way. And then you have post-trial motions.
Which is, we have just a brief amount of time.
Motion for additor, they didn't give me enough money. Motion for remitter, they gave him too much money. Motion for a new trial.
Good to know. We thank you for tuning into The Law Matters. As we say, it matters to you. We hope you'll stay tuned to the next episode.